Hi, Ariana.
Hi. Hi, everyone. Welcome and thank you for joining us today. Um, I'm Ariana from Marsh Fidelity. I'm an attorney and I've been a member of Marsh Fidelity for just over a year. We have a very special guest today. This is Jenna. Hi, Jenna.
Hi, everybody. My name is Jenna. I am an attorney, notary public, and conveyancer from AMC Hunter Inc. Attorneys. It's a very established law firm in the Greater Durban area that has been in practice for almost 40 years. So, yeah, nice to see everybody.
So, so amazing. We're very excited to have you here, Jenna, today for our live discussion. We're going to be discussing some very interesting topics. Would you like to tell us a little bit about yourself and your journey into property law
Oh,
first before we start?
okay. So I obviously started just as a normal attorney. I did my articles in Pretoria, and then when I qualified as an attorney, I moved back to KZN, which is my hometown. During my articles, I wrote my notarial exam, so I passed that. So when I was admitted as an attorney, I was admitted simultaneously as a notary public. So a notary public is a very specialized type of attorney. We specialize in the drafting of specific contracts, such as antenuptial contracts and notarial bonds, notarial deeds, notarial sessions for exclusive use areas, things like that. And then once I was admitted as an attorney and a notary public, I studied for the conveyancing exam, which I wrote and passed, whereafter I was admitted as a notary, a conveyancer in 2020. So I've been practicing as a conveyancer for 4 years now.
Oh, such an inspiring journey. A lot of hard work that went into all of that,
Lots
the
of
different
studying,
admissions, a
yeah,
notary and a conveyancer.
yeah, but here we are.
Definitely. It's so exciting to have you here today, and we're going to be discussing a lot about property, which is obviously your specialty.
Yeah.
Um, could you tell us why you like property law? What's the best thing about practicing in property law?
I think it's one of the areas of law which is very positive. So often when people, think of a lawyer, go and see their lawyer, it's sort of a negative experience. And generally, if you need a lawyer for something, it's because you need advice and you're possibly not going through, the greatest time with something. So I think conveyancing is a very positive area of the law. We assist people where they are buying properties and selling properties, and most of the time that is a very happy occasion for people. It's very exciting. So that is wonderful to be a part of that, to assist people through what's probably going to be the biggest purchase they will ever make in their life. I think there's always a positive outcome. Someone is very happy, is happy to be selling, and just to be the person with the expertise to guide through that and get that transfer over the line. I think that's what's most enjoyable.
Wow, wow. I definitely agree. It's such an interesting area of law and something where you can make a big difference in people's lives, and you see that on a daily basis.
Yeah, yeah.
Definitely. So today we're going to be discussing interesting topics, which is marital property regimes and how this impacts when buying and selling property, as well as on your estate planning. Obviously, at Marsh Fidelity, we specialize in estate planning, deceased estate administration, and trust management and formation. So I'll be talking more from the estate planning side, whereas Jenna will be speaking from the perspective of a conveyancer and buying and selling property. So first off, we have 3 marital property systems in South Africa. And obviously, each system will impact how you can buy and sell property and how your marriage will be regulated.
Yeah.
Jenna, would you like to tell us about marriage and community of property as a starting point?
Yeah.
Just something from your side.
Okay, so yeah, in South Africa, we have 3 different marital property regimes. So the one property regime is a marriage in community of property. The other property regime is a marriage out of community of property with the inclusion of the accrual system. And the third one is a marriage out of community of property. So let's start with a marriage in community of property. So if a couple is going to be married and they don't conclude an antenuptial contract before a notary public, on the day they get married, their marriage will automatically be one in community of property. So in terms of that marriage property regime, everything is 50-50 in the marriage. Everything is split 50-50. You require your spouse's consent. For example, when you purchase a property, the property will have to be in both of your names. When you sell the property, even if it is registered in one person's name because you bought it before you got married, when you sell it, if you are now married in community of property, your spouse will have to sign the necessary documents to authorize that transfer. So you will find it's quite an old-fashioned way of getting married. You don't find a lot of young people these days who are getting married in community of property. You find a lot of our parents and our grandparents are married in community of property. That said, I mean, you do still find people that choose that route, but it does limit your capacity as to contract and things like that. And then we will talk, I think, a little bit later about the impact on, you know, a deceased estate should one of the spouses pass away. So that in a nutshell is one of the marital property regimes. Do you want me to chat about the others?
No, we'll continue.
Okay.
So definitely, marriage and community of property is seen as the traditional system. It is, like you said, mostly the older generation who entered into the scheme because it was seen as more fair. You know, both spouses share equally in everything in the estate. And from an estate planning perspective, it can be useful if one of the spouses has a greater estate, has a bigger estate. Because for the purposes of estate duty, your estate is halved on when one of the spouses dies. So that lessens your estate duty liability, which is tax on death, basically. So that is one benefit of a marriage and community of property for your estate. But like you said, when you're buying or selling property, you need your spouse's consent to buy or sell, as well as to apply for a bond because getting credit as well.
Something to note is that if you as an individual were to accumulate any debt in your capacity, for example, to sign surety on behalf of a business in your personal capacity, when you're married in community of property, you're liable for 50% of that debt too. So, for example, if issue summons against somebody who was married in community of property, they would issue it against both spouses. So that is always a risk, you know.
Yes, definitely. It's a big risk as well, especially with the high divorce rate and the rate of business failure as well. But there is another option for your estate planning. If you are married in community of property, you could always also set up a trust and then move assets out of your personal name.
Yes.
So then you can share in your personal estate, but you can also have assets that are protected from your spouse's creditors. Yeah. So then I think we can... If you could talk about more from buying and selling property for in community, what should spouses look out for when they signing an offer to purchase or to sell?
So if a couple is married in community of property, we often get couples that come to us and they will, you know, for example, when we have people buying or selling, the most important thing we have to do at the moment is to FICA them. And one of the things we have to find out is how they are married, whether it's in or out of community of property. So we often have clients come to us and tell us that they're either selling or buying, and that they tell us they're married out of community of property. But then when it comes time for us asking for a copy of their anti-nuptial contract, they have no idea what we're talking about. And sometimes we have to have that difficult conversation with clients where we have to explain to them that they're actually married in community of property. And that can come as a shock sometimes to the clients. And I promise you, this is something that has happened on more occasions than I'd like to name. And I think it comes from ignorance, is that people are not educated on anti-nuptial contracts and the purpose thereof and the different marriage regimes. And I think for a lot of couples, when you're young and you get married, if your parents don't guide on that, how are you to know? So something that AMC Hunter is starting to get involved in. We're starting to get involved in the world of weddings and wedding planning, and just trying to get the word out there that it is important to have an anti-nuptial contract, and that, you know, all these people in the wedding industry can put us in contact with their clients should they need advice on that, because it is something that pops up.
Definitely. Yeah. That's so important, actually. When you're getting married, that's the last thing you're thinking of is, you know, getting divorced or your spouse dying. But
it's maybe think it's an awkward conversation to have, but when I meet with my clients, it just say it's absolutely not an awkward conversation. If you're at the point of getting married, it's perfectly normal. It's something that needs to be discussed, and then we can advise them accordingly. So yeah, I think so if a couple comes to us and they are married in community of property and they're either buying or selling, the most important thing is that they both need to sign the sale agreement. And that's also something that pops up from time to time, is that only one of the spouses would have signed the sale agreement. So, the spouse cannot contract on their own. The other spouse needs to sign and needs to be involved with that, give their consent. Going forward, once the sale agreement is signed and we proceed with the transfer process, we will have both spouses sign transfer documents, and I will be required to FICA both of the spouses as well, if they are married in community of property.
Good. Yeah, it's definitely so important. Also important to note that marriage in community of property is the default system. So if you don't register an antenuptial contract or enter into that before your marriage, and you just marry at home affairs, for example, without thinking about these, then you will be married in community of property.
And I think something that's very important to point out, and something that also popped up on numerous occasions, just my time being a notary, are customary marriages in South Africa. So the law currently stands in terms of the Customary Marriages Act in South Africa, that if a couple enters into a customary marriage and they go through all the ceremonies, so they are both 18 years and older, they both consent to the marriage, and all the traditional ceremonies have taken place, like umbeso, the lobola has been paid, and they are now regarded as being married in terms of the customary law. If they have not concluded an antenuptial contract, their marriage will be one in community of property. And you will then have to go through the process of applying to court to change your marital property regime if you haven't concluded an ANC. So it's important to advise clients that before any additional negotiations start, that they should come and sign an ANC with us, because otherwise they will be married in property.
Definitely. That's so important to note. Also, the type of marriage that you enter into, because there are various types, like you mentioned, customary marriage. So there are several types of marriages. Basically, a civil marriage, which is what you would call your average, normal man and wife marriage. So that's with the different property systems that we mentioned. And then you can also get a civil union, which allows same-sex partners to have a marriage which is identical to a civil marriage.
Yeah, I mean, we would do an ANC for those couples as well.
Yes. So they can also enter into the different marital system regimes. And then, like you mentioned, there's a customary union as well. And then religious marriages, this is a hot topic at the moment. They're not officially recognized yet, but there's a lot of development happening in this area. So definitely watch out for news in the next few years on religious marriages.
Case law is starting to come out, giving judgments on that, and I think it's great. I think it's really important, and it's important in a house where we have so many different cultures and religions and so many different languages, that the various types of marriages are recognized. South Africa is making a start with the recognition of customary marriage. So I think it's only a matter of time before all the other different types of marriages also start making
Definitely. It's the developments are great. They are long overdue. And there are some exceptions, though, slightly from the estate planning side. So religious marriages are actually recognized for the purposes of the Intestate Succession Act. So if you are a partner in a permanent lifelong relationship that is seen as either in terms of religious marriage or as a same-sex partnership, you can actually also get some protection from the law from that side.
Maybe, Ariana, I can ask you a quick question, because it's a question that I sometimes don't always know the answer. So if you have a couple that never officially got married in a religion or otherwise, and they have been living together for a long time, sometimes 20, 30 years, and one of them passes away, does the other partner in that relationship have any rights or anything in terms of the deceased estate? Like as a life?
Yeah, it is a complicated question, but the main answer usually without considering the entire situation is no. There's no protection for permanent life partners that aren't married, except some exceptions.
Okay.
So, like in the Intestate Succession Act, it does allow for permanent life partnerships, but only of same-sex partners at the moment as we stand. So there are developments in this area as well. But yeah, I would advise in that situation to speak to an attorney who is specialized in this area, so they can advise you based on your particular situation as well.
Okay.
And then something in that case that is a good idea to look at if you are in a permanent life partnership is a universal partnership. So this is basically setting out a contract that looks at you and your partner's relationship and how you would like to deal with your assets in your relationship without being married.
Okay.
Yeah, but like I said, I would advise to speak to a professional first before entering into any of these kind of agreements. So I think we can move on to the other types of marriages. So there's in community of property and then out of community of property.
Yeah.
Would you like to briefly explain the two types of out of community of property marriages?
So a marriage out of community of property is always a marriage where an anti-nuptial contract has been concluded. So in the case of an anti-nuptial contract, it has to be signed before the marriage. It has to be registered in the deed office within 3 months of the so from my side, what I will do is if I meet with the clients and I will have them sign, I will send my stuff to the deeds office immediately and be registered regardless of when they're getting married. But it is also an issue which has popped up in my days of conveyancing, is I came across a couple which were selling a property, and I noted that the anti-nuptial contract was dated after the marriage. And then they advised me that what had happened is that the attorney who assisted the ANC never sent to his office and it wasn't registered in time, in which case they were married of property and they had to apply to court to change their matrimonial property regime. So there's quite a high level of care on us as notary publics to make sure that this is all done correctly and that being said, I find with clients on the Saturday morning of their wedding. They get married at 3 in the afternoon. I've met with them at 9 in the morning and they sign their ANC. That's absolutely fine, so long as it's signed before they get married. So there's two options when signing an ANC. You can choose to be married out of community of property with the inclusion of the accrual system or with the exclusion of the accrual system. So with the inclusion of the accrual system, that means everything that you enter the marriage with is yours and yours only. Then from the day you get married, anything that you accrue in your personal capacity will be split 50-50 on dissolution of. So what I sometimes do is I draw a little picture for my clients. I'm not going to be able to do that now, which sets it out quite nicely in a way that's easy to understand. But if I can try and explain it as best as I can without drawing my picture, is that, for example, you enter the marriage, get married when you're young and you don't own any assets or anything. And then during the subsistence of your marriage, for example, one of the spouses accrues an estate worth, I'm going to use very simple, accrues an estate 50,000 Rand, and the other spouse is the spouse who has been the breadwinner, been working, and they accrue an estate of 100,000 Rand. So on dissolution of marriage with the accrual system, you would take the value of each estate of each of the spouses, one being 100, one being 50,000. You would calculate the difference. The difference between these two estates is 50,000 there, and you would then divide between two, 75,000 Rand. So each spouse will come out with 75,000 Rand at the end of the marriage. So a lot of couples choose to go with that matrimonial property regime. They see it to be the fairest. They say, everything that we get in our marriage, we want to be split, we want to share in it. So that is a very, very popular choice for young couples. The other type of matrimonial property regime is a marriage of property with the exclusion of the accrual system, which in very simple terms, what's one spouse is theirs and what's the other spouse is theirs. There is no sharing. There is no sharing in that. For those couples, for some couples, they say they want to keep everything separate, and for example, make a big purchase, like purchasing a property, they would put it in both their names anyway. And as a notary, you know, it's not my job to give my opinion to any couples. I just advise them. And it always depends, you know, on a relationship by relationship basis. So we give couples all the information. Sometimes, you know, my couples will come and see me. I'll give them all the information, and they will go home and think about it or chat to their families and stuff. They will come back and tell me what they've decided. So yeah, in a very small nut. That's
Definitely. Well, thanks for that. Yeah, it's definitely important to note that you can still own property jointly if you are married out of community of property. So that is always a good option to do as well, if you still want to share in some of your assets.
And just something to know from like a conveyancing point of view is couples married out of community with the inclusion of the accrual system, you don't need your spouse's consent to buy, or you wouldn't need their consent for that. So you can contract independently without their consent, which is great.
Definitely. Yeah, I think out of community of property is a more forward-thinking way. It is definitely seen as you can share in some of the growth of your estate, but also have protection from creditors of your spouse. Yeah. Exactly. Especially if they're involved in business and such. Sure. It's always a good option. But one thing to note from an estate planning perspective, if your spouse is not mentioned in your will and you are married out of community or property, your spouse is completely excluded from your will, so that from your estate, they can't share in your estate at all. So that's something definitely to keep in mind, that if you are married out of community of property, you should definitely update your will to include your spouse if you haven't updated it in a very long time, because it can cause problems if one spouse passes away. But also out of community or property without accrual, another thing to note is that this may not be an ideal marriage system where one spouse, for example, gives up work to look after the household or the children during marriage, because then they won't share in any growth of the parties, the spouse's estates.
Yeah, absolutely. So that again would depend on the spouse's preferences, and you know, something which I've learned, having also, you know, practiced a bit of divorce and family law during my time as an attorney, is that, you know, something that people, when they're getting married, is often very what couples would agree to on of the marriage. So you always need to try be forward thinking and planning ahead, and understand that you might not always be in agreement on now. In the future, you know, things change, and you know, you might have children which you need to consider down the line. So it's actually a really important decision to make, and something where you should make sure that you are educated on, you know, all the facts and have all the information that you possibly can to make an informed decision on that.
Definitely. It's also important to note that with a marriage out of community with accrual, this will mean that on dissolution of the marriage, either on death or divorce, it means that one of the spouses will accrue a claim against the other spouse's estate for that growth, the difference in the growth of their marriages during the estate. So if you, in your estate planning, you should also consider this, whether there is sufficient liquidity in your estate to be able to pay that claim back if you are the spouse who is being claimed, whose estate is being claimed against for the accrual claim. Yeah. And then another question that we've actually had about antenuptial contracts recently from a client. If you lose your antenuptial contract, what happens then?
So you always need the original antenuptial contract to present to the court on the day divorce is finalized, should the marriage dissolve. For, you know, contracting, generally a copy is acceptable, but if you have lost your antenuptial contract and you no longer have the original, you can apply to the deeds office for a certified copy, and they will assist you in that regard. So it just requires a application whereby you just declare under oath have lost or misplaced your antenuptial contract, you don't know the whereabouts, and it's the same process that we would follow, for example, if a seller loses the title deed, which also happens. So we certify to the deeds office that they have lost it and they don't know the whereabouts, and the deeds office will provide you with a certificate.
Thanks. Thank you for that. Also, one question that we've been asked is, I know you mentioned it briefly before, but can you change your marriage system after you have entered into an antenuptial contract or been married in community of property? And what does this involve?
Okay, so you can. It's not an easy process. It does require an application to the High Court, and you would need to show valid reasons to the court for your wish to change your marital property regime. So, for example, what I mentioned previously, where there was an error on the notary public's part in not submitting the antenuptial to the deeds office timeously, that is a valid reason. The couples had the intention to be married out of community of property. They signed the antenuptial contract timeously, and it was an error on the notary's part. So that is, for example, a valid reason that the court will accept. I have had clients come to me and ask for advice where they've been married for 20 or 30 years and they're married in community of property, and now they sort of, for example, trying to dodge creditors or like that, and they want to change their matrimonial property regime. It's going to be very difficult to the court that there are valid reasons there for wanting to change the matrimonial properties regime where you've been married for such a long time. Every case will be determined on a case-by-case basis by the court. So if you can convince the court, for example, that perhaps you were ignorant, you didn't receive proper advice on the topic, I think those are sort of things that courts will accept. But it is a costly process. It does require having an attorney involved and bringing a formal application to the court. But for some couples that will be worth it because it is the rest of your lives, it is the rest of your marriage. So it can be changed, but there are a few hoops that.
Well, thanks for that. Yeah, definitely. I'd like to add there as well that one thing you would probably have to show the court is that you're not wanting to change your marital system just to defraud creditors. So you're not trying to do it to avoid having to be liable for your spouse's debts as well. And like you mentioned, it's quite a costly process because it involves a high court application.
Yeah, and maybe there is an example where couples were married without the accrual system. They now want to include the accrual, because, for example, they've had a child and they feel it would be more fair for the child. That those are all valid reasons that the court will consider. But if you don't have valid reasons and you spend the money with the situation where you paid all this money for lawyers' fees and you bought the application and the court rejects it. So, yeah, it's just something to consider.
Yeah, definitely. It's so important to consider these things. So from the perspective of buying and selling property, what would you look out for, or tell couples to look out for when they have entered into an antenuptial contract? So they are married out of community of property, either with accrual or without. Is there anything they need to be aware of or consider there?
So I think just to note that if you are married with the accrual system, buying a property, the property can be just in your name. Your spouse doesn't need to sign the agreement or any transfer documents, and just your name would go onto the title. But you do need to bear in mind that should the marriage be dissolved and you have now purchased this property during the subsistence of the marriage, the value of that property will be included in the accrual calculation, which is quite important to note. And then if you are married out of community property with the exclusion of the accrual system, it's important to note that the property will be just in your name. And if you share it with your spouse, then you both sign the sale agreements and have both your names on the title deed.
Definitely. So when entering into an ANC contract, are there any tips you would give prospective spouses about what to include or what not to include? Anything just to look out for, be aware of when entering into an antenuptial contract?
So I think something that's important and is important to think about and take note of is that in the antenuptial contract, we would always include a starting value for each respective spouse's estate. So if you're a young couple and you're getting married and you don't own any assets, you maybe have a little bit of savings in your bank account or something, but you don't own for couples like that, most of the time we agree on a starting value of nil, because your starting value is always taken into account when calculating how much your estate has grown. if you are someone who's getting married, and you do, for example, already have a large estate, perhaps you own a lot of properties, you have a large estate or anything like that, we can then include the starting value of your estate. So on my previous example where I mentioned where they started both with a value of nil during the subsistence of their marriage, one spouse's estate grew to 50,000, the other to 100,000. Had the spouse whose estate accrued to 100,000, had they entered the marriage with a starting value of 50,000, and then when the marriage was dissolved, they now had 100,000, their estate would only have accrued by 50,000. In which case, there would be no splitting of the accrual. So that is just important for clients to think about, is starting value. And then I think something that's also important to note, and this touches on what you do, is that any inheritance is excluded from the operation of the accrual. And that's also something that I know is often included. Maybe you can just touch on that, Ariana, is that, in of the accrual calculation, any inheritance won't form part of that.
Yes, no, that is correct. Definitely, inheritances are excluded unless you specifically state that they are included in your marriage regime. Sorry. Yeah, no, definitely that is correct. I can confirm.
So we often a clause like that in our will, although it's automatically excluded. Some clients, just for their own peace of mind, like to have that included. And then something else is that we can tailor an anti-nuptial contract to suit the clients. For example, we can exclude specific. I had couples where I've excluded, for example, any asset they should earn from a specific business or from a family trust. So those would not be part of the accrual system, anything like that. So we can tailor the anti-nuptial contract to exactly what each couple needs. It's not just a standard form that everyone has to. So if couples they have specific requirements or needs, we can definitely and personalize it.
I can ask as well. So when entering into a anti-nuptial contract, like in movies where you see people putting ridiculous clauses in a prenuptial agreement, is that advisable, or what cannot be included in an anti-nuptial contract?
So I think it's like an open-ended question, and most things can be included. I think if a client were to bring me a specific situation, and we could chat about it, advise them accordingly. The number of things that can be included or that clients come up with is endless. But yeah, I think definitely you can tailor it to suit the client's needs completely. And I also had a situation where I had a couple, and they were wanting to exclude this, and eventually reached a point where I just said, if you're excluding pretty much everything, you're better off getting of the accrual system. Because ultimately then that's what this anti-nuptial contract is going to be. So although we don't give our opinion to clients on which regime we think is best, personally guide them on on how to go about.
Yeah, definitely. That is good to know that you can tailor an ANC contract to the specific couple's needs, and that they should speak to their notary, of course, about this before entering into the contract and seeing what is best for their situation. Another thing that's good to note about ANCs is that it is the default system that if you don't specify, expressly exclude accrual from it, you will be out of community with accrual if you enter into an ANC.
Yes.
Okay. That is correct. So would you like to add anything else about ANC contracts from the view of a notary? So what does it mean to actually be a notary, and what else do you do besides ANC contracts?
So I think it's important for clients to know that you can only conclude ANC before a notary public. We are not just your average attorney. We are a specialized attorney. We are held to a higher standard than attorneys. So you would have to make an appointment. For example, in my case, I can't speak for other notaries. Make an appointment, come see us, and then I like to sit with both couples together, because I think it's important that both couples hear the same information coming from me, and are educated simultaneously and can ask questions and things like that. So I normally sit with both the couples and we chat through all the various options. They can ask questions. Like I mentioned, they can go home and think about it. Other couples come into me, they already have information that they've either, learned from friends or family, things like that. And they already maybe know which regime they're going to choose. As my duty as a notary, I do always just speak them through it again and make sure that they fully understand. And then I go through the process of drafting the documents. They will then come through and sign the antenuptial contract, and I send everything off to the deeds office. So as a notary public, there's certain things notary publics can do. So for example, executing an antenuptial contract is one of them. Only a notary public can notarially certify documents for use, in other countries. Only a notary public can attend to apostille certificates, and only notary public can attend to notarial bonds, notarial deeds, notarial cession of exclusive use areas, to sectional titles. So I think the best way to describe us is that we are just a very specialized type of attorney who specializes in drafting of certain contracts, most of them to be registered in the deeds office.
Okay, thank you for that explanation, because I think a lot of people, there's a misunderstanding about lawyers in particular and attorneys, different types of attorneys, the very specialized types. So you mentioned that you're an attorney, a notary, and a conveyancer. Could you explain what a conveyancer is and more about this to us?
So a conveyancer is a specialist of attorney who specializes in the transferring of a movable property. So in order to transfer a movable property from one person to another person's name, you have to go through the formal process of transferring that property, changing the names on the title deed in the deeds office. So most provinces have a deeds office. In KZN, we only have one deeds office. It's located in Pietermaritzburg, and a conveyancer is absolutely essential when transferring a property. You can sell a property privately without having a state agent involved, but you can never transfer a property without a conveyancer. We are the ones to sign off on the documents which go to the deeds office, and we are absolutely essential. You cannot do it on your own. So you can sell your property privately, but you will always have to have a conveyancer involved to attend to the conveyancing process. So that's what I on. That is what we specialize in at AMC Hunter, is the transfer of immovable properties, the registration of mortgage bonds in the deeds office over properties, and then the cancellation of mortgage bonds when a property is sold. If there's an existing mortgage bond over that property, we cancel it. So being a notary public and a conveyancer hand in hand, which are decided to go the extra mile, because they do work together, and it is beneficial to be both. And then an attorney, commercial work, I have practiced doing on family law, commercial litigation, all things like that, where you don't need to pass a specific exam to specialize as being a commercial attorney or doing divorce or things like that.
Wow, so inspiring, your journey. What are some of the steps that you need to take to become a notary or a conveyancer?
So, when I wrote the notarial exam, there's a specific exam you write. It's set by the Legal Practice Council. I was still a candidate attorney at the time. So there's various institutions which offers courses and notes and things like that. So I purchased the notes. I actually just sat and self-studied. I'm very good at applying and sitting and studying. So I sat and self-studied for that. And then I was lucky enough to pass first time and then be admitted as an attorney and notary simultaneously. The same process applies for conveyancing. The conveyancing exam is a little bit more complicated. The content is a little bit more. So I think for notarial, I must have studied for about 3 or 4 months. For conveyancing, I studied for a good 6 months. I did attend a course on conveyancing to just assist me and guide. And then I sat and studied all notes at home. And the conveyancing exam, it's actually 2 exams, right? And you have to get 50% for each of the exams in order to pass, whereafter you then get it as a conveyancer of the High Court of South Africa.
Sure, such dedication that involves to go through this, all those processes.
My days of studying are over now because I have done a lot of studying.
Definitely, it takes an immense amount of dedication. So congratulations for all of that. It's amazing to see your journey, so inspiring. So are there any last points you'd like to advise about when coming to see your notary or your conveyancer for these matters?
I think the first is don't let attorneys rip you off where anti-nuptial contracts are concerned. We do find that there are attorneys out there which are charging exorbitant fees for anti-nuptial contracts. The cost for anti-nuptial contracts are charged in terms of the tariff, which is released by the government on a yearly basis. And that is how we charge. Our fees are completely fair. They are determined by the government on a yearly basis. So maybe just phone around and get some quotes. And I think, what we're doing here today is like getting the word out there about anti-nuptial contracts and the importance of it. And I think that's what I think attorneys and people like you guys at Mass Fidelity need to do is get out there. It forms part of estate planning, future planning. So we've decided to enter the realm of wedding and wedding planning just to try and educate people as much as possible, because my heart really breaks for clients when they come to me and they're out of community of property and they're not. And I do have to have that conversation with them because it does affect relationships and it affects finance, it affects business, it affects everything like that. So yeah, I think working together and getting the word out there and just educating the public about the importance of anti-nuptial contracts and who notaries are and what we do, and we're not just old things sitting behind our desks that are very scared to come and chat to. We're very approachable and we try to accommodate clients wherever we can. So, yeah.
Definitely, we agree completely. That's why we started this live discussion series to talk about some issues that really impact estate planning and your estate when you eventually pass away or get divorced or married. Things like this that really impact your life essentially throughout life. Yeah. So I think we've discussed a lot today, and we've gained some really good insights for our followers today. So thank you everyone for joining us today. If you do have any questions, feel free to pop them in this video. We are going to post this video live onto the Marsh Fidelity page, so you can rewatch after this live has ended. So definitely ask us any questions you have, and we'll try to answer there as well.
For me, you're welcome to follow us on Instagram, and if you have any queries, pop them through. We have a very active, interactive website for AMC Hunter Inc. So I think if you are looking for very experienced notaries and conveyancers with years and years of experience, we are definitely the place to go.
Definitely. We advise definitely to speak to your attorney, your notary, or conveyancer, depending on your legal needs, before entering into any kind of contract, specifically these ANC contracts as we've been talking about, as well as drafting your will, because all of this will definitely impact your not only your estate planning, but how you can buy and sell property and interact legally during your lifetime.
Yeah, absolutely.
Well, thank you. So thank you everyone for joining us today. And thank you so much, Jenna, for joining us as well and sharing with us. It was very insightful to learn everything that you are doing and what notaries and conveyancers and attorneys are doing in this space.
Absolutely.
Thank you so much.
I love to share the knowledge and to, let people know who we are and what we do. And, it is important. So thank you for inviting us and letting us be a part of this. You guys are also doing amazing work. We love working with you. So
thank you so much. So it's the pleasure is all ours. Thank you so much.
Thank you.
So we will post this video again. Ask us any questions you have and we'll respond on the comments. Thank you.
Thank you. Bye.
Thanks. Bye. Bye.